Good afternoon, everyone. Thank you for joining us for today's webinar, Board Governance, the Fiduciary Responsibility of New Trustees. This is a co-hosted webinar between Armanino and Liebert Cassidy Whitmore. And so let me start off with a couple of housekeeping items. You can maximize or minimize the webinar pane during the presentation by using the red arrow buttons. During the webinar, we also encourage you to ask questions. In the webinar pane, you'll see a chat box that you can use to enter your questions. Just type the questions and hit submit. During the webinar or at the end during the Q&A session, we'll make sure that we have time to answer those questions. Next, let's chat about your audio settings. If you're calling through your telephone, please click on the Use Telephone Audio mode. If you're listening through the computer, then please click Use Speaker or Use Mic and Speaker option. Also, please note that if you're dialing in for CE, that you'll receive a confirmation within 72 hours and a copy of the slide deck. To qualify for CE, some very specific requirements that you have to complete. You must be using a personal computer, no PDAs, and be logged into the system with your own information and unique URL. You must be logged in to our online software for at least 50 consecutive minutes within the scheduled time frame of the webinar. Actively respond to at least 75% of the polling questions. There are 4, which means you will need to answer 3, and you must complete the evaluation survey at the end of the webinar. Now, a quick introduction to our presenters. First up is Dean Cuyambo, partner with Armanino. He has more than 12 years of experience as an auditor and has transitioned to our sort of chief relationship builder, we like to call him. He helps numerous private schools, social services, performing and fine arts organizations address their tax, audit, and outsourced accounting needs. Boards and finance folks have grasped his laser focus on bringing life to the audit items that are most important to them and their particular industry. Next, we have Michael Blocher. He's a partner with Liebert Cassidy and Whitmore. He represents clients in all aspects of labor, employment, and educational law. He often advises boards on governance and other issues, including updates to bylaws. He works extensively on contractual matters, such as employment and enrollment agreements, as well as employee and student handbooks. Next, a quick overview of our learning objectives. So during today's webinar, you will be identifying trustee fiduciary duties, the care, inquiry, and loyalty, and how they were developed. We'll recognize what qualifies as a conflict of interest, and we'll also be reviewing the responsibilities of the trustee with the role of management, the CFO, and the executive director. And with that, I'll turn it over to Dean.
Thank you, Debbie. Today we're going to talk about numerous things, primarily the sources of trustee duties, conflicts of interest, confidentiality obligations. It's right after lunch and I can't talk. I apologize about that. Trustee liability and responsibilities, and always the ever popular role of the board versus management. We touched upon that in our last webinar with Marilyn Gardner, the former CFO of De La Salle and audit committee chair at John Muir Hospital. And we're going to follow up on that again today and kind of talk a little bit more. Very happy that Michael is with us, and with that, we'll jump right in.
Thank you so much, Dean. Well, I am happy to be here and happy to participate. Oh, can we go back one slide? Sorry. Thank you. I'm not the most technical person in the world, so if my animal magnetism is throwing off the electronics, I apologize for that. I'm happy to be here and have the opportunity to talk to you about this issue of trustees and their duties. I wanted to say before we get into some of the details, first of all, that I know we're going to have a Q&A session at the end. If people have questions as we go along, I believe they can type them in, and Dean and I'm sure we'll do our best to respond to them. Some may have to wait. I also wanted just to share with everybody, really, as we start on this, that I'm constantly surprised when I'm working with nonprofits and their boards about, frankly, how little thought is given by the organization to who they select as a board member. And on the flip side, even by the board members themselves, in terms of what it means to them when they decide to go onto a board, when they take on that responsibility. So what I'm going to try to do today, I mean, we have limited time, obviously, but I'm going to try to hit on the main issues that I think think not only trustees need to be aware of, but really organizations need to be aware of when thinking of who it is that should be on their board. Some of the things which we'll talk about sort of here and there as we go through the presentation is the purpose of the organization, and if somebody's going to be on the board, really embrace that purpose, or have they just decided that they want to be able to tell people that they're on this board? You should really think about how the board functions. Boards function in different ways. Both there's a full board and an executive committee, and what's right for your organization is something to really give a lot of thought to. On a very basic level, I see people join boards all the time. They don't know really what their legal duties are. The organizations don't provide training to new board members to make sure they're aware of their duties, and that's really something that I think should just happen with every organization. And I'm also surprised that the new board members never ask about what protections are in place for them. If I join the board and the board gets sued, what protections do I have? And I think it's something you should think about in terms of, if you're going to have new board members on, what kind of, and frankly, even if you have existing board members, you haven't discussed these issues with them, what kinds of things should we be talking about ahead of time? So anyway, I just wanted to put that out there. A lot of times when there are issues and I'm involved and I'm talking to a board chair or somebody about, how is it this person got on the board or what are they doing, they often say, well, this is somebody who gave a lot of money, this is somebody who had a particular expertise, and while I understand those reasonings, frankly, those are precursors in my mind for getting on a board. They're not necessarily the entire qualifications for being on a board. So anyway, I just wanted to set that out at the beginning, because those are the kinds of issues I deal with generally with boards, some of the things that I think should be kept in mind as we go through this presentation.
That's definitely great, Michael. I think we see so many people who join boards just because they feel like it's the right thing to do. But as the main reason of what we're doing this today is now what? I'm on the board, or they've asked me to join. What does that mean? So let's walk through that.
Great. So some of the sources of trustees' duties, there are laws. The Corporations Code, which we're going to talk about, sets out a lot of these duties and obligations. One of the first things, depending on who I'm working with, that I'll ask an organization, a nonprofit, if it's a religious nonprofit, is how did they incorporate? Are they incorporated as a public benefit corporation or a religious corporation? And I'm not going to get into all of those details. We don't have time, and it frankly doesn't apply to everybody on the call, but I did notice there were some religious corporations. And if you're not sure, then you should check, because the way you're incorporated will have a direct effect on legal issues that may come up. And in almost every case where I ask that question, people look at me and they have no idea what I'm talking about. I think I shared this with Dean earlier, but one of the funniest, frankly, situations I dealt with in this regard was when I had to ask an organization how they were incorporated. They didn't know, so I asked them to get their articles of incorporation, and it turns out that they were formed as a homeowners association, and they were a school. They were not a homeowners; they were a school. And when I asked them how this could be, it was because they had an attorney on the board who was a real estate lawyer who offered to, put together the articles, and that's just what he knew. But that created problems for them. It's funny to me in a way, but it created real legal issues for them. And so, when it comes to the governing documents, the articles of incorporation and the bylaws, and we're going to talk, about the bylaws some more, I always say those are the two most important documents that nobody ever reads. And it's really important to be familiar with them. The articles really set out, the obligations of the organization, why it was formed, what it is. And that's hardly ever changed, frankly. From time to time, for various reasons, we may touch upon them. They can be updated. But the bylaws are something that really you do need to be familiar with. The bylaws set out how the board functions. And what I find a lot of the time, I would say most of the time, is that people are not familiar with the bylaws. People are not following the bylaws. They just have their own way of doing things. Boards sort of evolve. And it's, it happens that way for a while because it's not a problem until there is some issue. And sometimes the issue is you have a split within the board. There's some issue that becomes a hot button issue. And then someone, probably the attorneys you have on the board, will look at the bylaws. They'll realize things aren't being done properly. And that can create not just legal issues, but really, in a sense, more fundamental issues in terms of the cohesiveness of the board and how it's being run. The other thing I just want to say about bylaws, and I was working on bylaws this morning, so they're on my mind. But one of the questions I get a lot from organizations is, what do we put in the bylaws? And there are some parts of bylaws that you need to have. There's some parts of the bylaws you should have, and sometimes I'm looking at bylaws and I'm wondering why anybody would put this kind of detail in. So while there's no necessarily right or wrong way to put together bylaws, I just want to put this out there for you to think about. I suspect most people on boards are not familiar with the corporations code. They're not familiar with what the law requires, even in terms of some of the things we're going to talk about in detail, like self-dealing transactions. So if people aren't going to know what the law says about that, and probably they can't reasonably expect it to be experts in that, I think it's fair to hold your board members responsible for being familiar with your own bylaws. And so having things in your bylaws, like what a self-dealing transaction is, what has to happen in those cases, what's not permitted, I think is important. There's other examples as well. And I also think it's a really good opportunity for organizations themselves to think about these kinds of issues and to think, well, here's what the law says on it, but do we want to have a higher standard? And we'll come back to that as well. Then there's other, you can see on the slide, written obligations, there's policies, there's certain filings. If you're a school, there may be education codes that are relevant. There's Form 990s if you're not a religious organization, and Form 199s. So a lot of documentation that I think often does not get considered enough until there's a problem that I want to encourage you to think about now.
And so when you think about standards and you think about trustee duties, just to set that standard for your organization, it's always good to remember the foundation for any nonprofit and that board governance model. And that reminds us all about the duty of care, the duty of loyalty, and the duty of inquiry. Just to remind everyone, and something that we should always be educating our board members on, is duty of care. So what does that mean? That's prudent use of the nonprofit's assets. And assets are specifically, or not specifically, but always should include both people, facilities, and goodwill of the nonprofit. Duty of loyalty, we need to make sure that board decisions are made in the best interest of the nonprofit, not in the board member's self-interest or best interest of the board member. And lastly, the duty of obedience. Ensure that the nonprofit obeys all applicable laws and acts in accordance with ethical practices, and that the nonprofit adheres to its stated corporate purposes and always tries to advance the mission of the organization. I feel like that's always a good level-setting reminder for all board members.
Okay, well, Dean's already talked a little bit about the duty of care. One of the things I wanted to mention, though, is you'll notice in the slide, refers to a director shall perform the duties of care of a director. And when I'm reviewing bylaws, I often see references to trustees rather than directors. And that may seem like semantics, but I will tell you that the Corporations Code is very specific in its reference to directors and the duty of directors. And on a couple of occasions, I've had to send in revised articles of incorporation to the California Secretary of State, and they've been signed by the President of the Board of Directors and others, and they will get sent back. While frankly, I find the Secretary of State to be responsive. When I've had to contact them for something, they actually will get back to me, which I always appreciate. But they're pretty humorless when it comes to deviating from the obligations under the Corporations Code. And so I've actually had situations where I've had to work with organizations to amend their bylaws to go from trustees back to directors so that we can then amend the articles in a way the California, that they will accept the Secretary of State. So one easy way around this, by the way, if this is an issue for everybody, is to have something in your bylaws that says you have a board of directors that will be referred to for purposes of bylaws as a board of trustees. But just make sure you have a board of directors, and when you sign things that they're signed in that capacity. Dean already mentioned things about good faith, duty of care. We are going to talk a little bit more about that later. The way to think about it, perhaps, the way I think about it is sort of as a negligence type standard. You have to use your best effort for things. You have to act in a reasonable way as a board member. And I also wanted to note on this slide at the bottom, you can see a reference to the Corporations Code. That reference is to public benefit corporations. Because I know there were a few religious corporations who were going to be on the call, I wanted to mention it's a different set of the Corporations Code that applies. And in this case, it's Corporations Code 9240. So I don't know if I'll mention it every time, but if you are a religious corporation, you look up the code and you think, wait, this doesn't apply to us, you're right. But I want you to know that there are other statutes that do apply directly to you. Okay, the duty of inquiry, Dean also mentioned that a little bit, I believe. The main point that I wanted to make, though, is that board members are entitled to rely on information provided to them by others. Now, the others that provide that information, they have to be competently providing that information. If you're relying on something you heard in car line at the school, that's probably not going to help. But if you have an employee with a specialty in something that's providing you with information, that's fine. If you have an attorney advising you, that's fine. You want to make sure the attorney is actually advising you in an area of law that they have expertise. I'll sometimes get calls from my family members asking me wills and trusts information, in which case I can't help them other than to let them know that one day they'll die and it'll be important, which they often don't appreciate. Yeah, thank you, Dean. I appreciate that. You know, I've had interactions with attorneys on boards. There was one that comes to mind always. I think it's actually a good example. I love working with boards. I love working with attorneys who are on boards, frankly. And we were dealing with a difficult situation with this organization, and the attorney said to me, you know, I'm a federal prosecutor, and if what we were dealing with involved, you know, cocaine possession, I would be the person you'd want to talk to. But because we're dealing with an issue around the bylaws in that case, you know, they needed to rely on an expert in that area. There's plenty of other examples that I could use as well, but it's important to keep in mind. I mentioned already the board member who was a real estate lawyer who wrote them articles of incorporation for homeowners association. But those are the kinds of things to keep in mind. You're also allowed to, Oh, go ahead. Sorry.
I was just going to say that also pertains to the accounting side as well. We do encounter numerous nonprofit organizations that they say that, we feel like we've outgrown our auditor or our nonprofit accounting partner. And we say, well, gosh, how many other nonprofits does your accounting partner work with? And they say, oh, some. It's kind of, maybe it's busy work to keep their staff busy through the summer. And you really get the feeling that they're really not experts when it comes to nonprofit accounting and some of the intricacies that go around with that. So just like Michael is saying, it definitely helps to be with an expert.
And something else that comes to mind, actually, I mean, it's easy for me to pick on attorneys, because that's the world I live in. But, I've seen it in other realms too, where there's a board member who just, likes to think of themselves as an expert in some area. And it certainly may be worthwhile to get their input, but you have to recognize when it's time to actually, get advice from somebody who is an expert. And another thing that just came to mind, actually, unfortunately, more and more I've been dealing with organizations when it comes to security, and I'm not a security expert, but the reason that I get involved is because when organizations have come to me and said, with everything going on, we really feel like we need to hire an outside consultant to give us some insight into our security. And by the way, security being everything from physical security of the height of walls and cameras, but also cyber security and things like that. What I tell them is, you actually want us, the law firm, to be the one to hire these experts. And it's largely a technical issue, but the reason is that then there's an argument anyway that the reports that they do, the advice that they give is going to be covered by attorney work product, and it's going to be privileged. And the reason you want it to be privileged is because, God forbid, there is some incident, you may not want somebody getting a hold of the report, which made 27 different suggestions. Of course, you couldn't implement them all. You couldn't implement them all immediately. You had to prioritize by cost and other things. And if in that report somewhere there's a recommendation you do something that you didn't do, that could create liability. So the duty of inquiry is something that you have, and I do get concerned when I'm either at board meetings or I find out later that something was just introduced and sort of happened and there wasn't really a debate about it. It's healthy to have debate, to inquire, to make sure you understand things. That's part of your duty. That's part of your obligation as a board member. There's a Corporations Code cited there. I just want to mention for the religious schools, it's Corporations Code 9241. That was all I was going to say about the duty of inquiry. Okay, so the duty of a loyalty really means that you have to put the interests of the nonprofit before your own. We're going to get into self-dealing transactions shortly, but one of the things I wanted to highlight, it's mentioned on the slide, but it's the business judgment rule, and it's a lot more exciting than it sounds. The business judgment rule is something that really gives a presumption to your organization that you've acted in a way that is loyal, that meets this obligation. There's an assumption that you're informed, that you've acted in good faith, and that you've acted in the best interests of the organization. And that's really important. It's really important because, to be honest, anybody can question what your organization does. They can certainly question the motives of individuals, the judgment of individuals, and the same is true for the board as a whole and the organization as a whole. And there's a very long line of cases. It's a very, frankly, old line of cases that talks about the importance of giving that sort of presumption to an organization. Because without it, anybody who's just unhappy, anybody who disagrees, would be able then to bring some kind of cause of action, and this protects you from that.
Awesome. Thanks, Michael. And now that brings up our first polling question. which is not one of the three pillars. Oh, are we launching it right now? Looks like we're launching it right now. Which is not one of the three pillars of board governance, and everyone needs to go ahead and answer this question so we can make sure that you get your CPE. Is it not loyalty, trust, care, inquiry, or not sure?
And as a reminder, while you're all answering, just wanted to give you all a heads up that we will be sending out a copy of the slide deck as well as a recording of today's presentation, just in case you want to reference it later.
Great. And looks like we've got about 75% voted. We'll let everybody click away so we can get your CPE in there. All right, and the popular answer was B, trust, and that is the correct answer for our first polling question. Not one of the three pillars. Trust is not a control, and it is not a pillar of corporate governance. All right, conflict of interest. This is a major area, and this is what boards need to know and ensure that it is going in the right direction for their nonprofit. So with that, Michael.
Okay, thank you, Dean. So conflicts of interest is indeed a significant area of the law. You can see on the slide there there's a corporations code that's mentioned, and just to get out of the way, for religious organizations, it's Corporations Code 9243. So a couple of things I wanted to mention about self-dealing transactions. I focused on the corporations code. When I was looking at the list of organizations that were participating, there were a few, and I'm not going to mention any names, but there were a few that looked to me like they may be public agencies. I mean, an example would be a charter school, but others as well. And so I'm just going to throw out there that if you are a public agency, it's not just the corporations code that would be relevant, but there's actually government codes. There's one called 1090, which has to do with entering into contracts, and one called 87100. And the government codes are far stricter than what's required or even permitted under the corporations code. So I'm not going to talk about it. I'm frankly not even sure that it applies to anybody on the call, but I did want to mention it, not just because it may apply directly to some of those participating, but I think it's important to mention because I think everyone should know that outside of the corporations code, when it comes to public agencies, there is a higher standard. And while it doesn't apply to you, when I'm working with boards, and I'm thinking about these issues with them, I do often find myself considering the standard that applies to public agencies, which is extremely strict, requires a lot of transparency. And the reason I think about it is because, nonprofits have been coming under a lot of scrutiny. The idea, I think, is that because you have that nonprofit status, more should be expected of you. And so, at the beginning of the presentation, I mentioned referencing specifically some of the requirements in the statutes so that people are aware of it. But when it comes to things like conflict of interest, I also spend a lot of time talking to organizations about whether they should have even a higher standard than is required under the law. Sometimes the answer is no, they don't want to have that higher standard. That's okay. Truly, it's okay. But what I really think is that it needs to be discussed. So what the Corporations Code says basically is that if you have a conflict of interest, and an example might be you have a board member, let's say who owns a security company, and says, yeah, you want to have more security, that's great. I'm happy to contract with you to provide that security, and I'm going to give you even a great rate on it. That's not illegal unless you're a public agency, but you can do that. But you have to make sure that the board has ensured that there's really a benefit to the corporation, so it's not just a benefit to this board member, that it's fair and reasonable, the contract they enter into at the time that it's entered into, that's one of the things that if you've read the news, you've seen there's been some cases involving nonprofits where allegedly anyway, that's not been the case. You need to make sure that the board member with the interest doesn't vote because of that conflict. And you have to make sure that the other board members are aware of the conflict of interest. And then the last requirement, which frankly is a lot like number 2, is they have to make sure that you couldn't get a more advantageous agreement somewhere else. And by the way, that's where, for example, the business judgment rule may come into play, because what is more advantageous? Well, things like quality, the board may say, yeah, we could get it cheaper somewhere else, but we think it's better here. And as long as you've, inquired about it, looked into it, everything is above board, you're going to be okay. One last thing, Dean and I talked about this earlier. I see some boards that have like their executive director, or if you're a school, your head of school, be a member of the board, but not be permitted to vote. Sometimes that's called ex officio, although it actually means something else, but that's the way that I see it. And that's not permissible. I'm simplifying the law, kind of, but it's basically that if you're on the board, then you have to vote, or you're not on the board and you don't vote. And that to me always comes to mind when dealing with these self-dealing transactions, because if you are a head of school, if you are an executive director and you're on the board, well, things like your salary, benefits of employees, those things may be at issue. We have always advised that in those positions they should not be board members. And I'm not willing to say there's no exceptions. I think there may be exceptions. But it's something really to keep in mind and to make sure that you're being thoughtful about it. Okay, I wanted to go on to the excess benefit transactions, the next slide. And Dean, you may want to weigh in on this, no pressure, but this is IRS requirement that says really you have to make sure that compensation is fair. And by compensation, I mean not just the money people are getting, but benefits that they're getting. You would take into account somebody's position, the size, complexity of the organization, and circumstances of that person. What I will say is that I think doing this analysis differs for a lot of the organizations I work with. For the smaller ones, they'll just get the Form 990s and take a look at it. They'll maybe call some other organizations. There's information that can often be obtained through regional organizations, things like that. And I think that's often fine. When I'm dealing with a more sophisticated or larger organization, all of that is code, by the way, for saying that they have somebody who's making a lot of money, who has significant benefits. You can actually hire organizations, companies who will perform this analysis for you. I don't recommend against it, but I will tell you that it can be very expensive. Again, it's something just to really think about whether it's something you need or want. And if you do, I would also really give thought as to the scope of what you're hiring them to do. I've seen some agreements where there's a lot of obligations to pay them for continued work that I'm not always sure is necessary.
Yeah, and for us, it's really coming down to two things. Number one, let's make sure that we've disclosed everything, that we know everything that you're telling your accounting partner, kind of everything that's going on, so they have a full grasp of the picture, and that way we can, disclose and talk about everything there. Also, that's where if your accounting firm is a specialist and they do work with lots of organizations just like you, they do have a better sense of what this looks like versus just I guess it looks fine kind of situation.
Okay, dual roles are also something to be wary of, and I'm not going to spend a lot of time on this, but I think it's worth mentioning that with the boards that I work with, most, and when I say most, I mean a huge percentage of board members are in some sort of dual capacity. I mean, when I work with schools, just about every board member is also a parent. I deal with situations. I mentioned attorneys, and like I said, I'm picking on them since I'm one of them. I sort of feel that I can, but you have attorneys on the board, and sometimes it's not clear. Wait, are you acting as a board member or as an attorney? Is what you're saying legal advice, or is that just how you feel as a board member? And it's not always clear. In some situations, I think that there's real conflict. Sometimes it won't just be a parent on the board of a school; it'll be a teacher on the board of a school. And I've mentioned the head of school too. So I'm not saying you can't do this, but you need to be really aware of the conflicts. There can be ethical issues that come up. If you have an attorney on the board and you're talking about potential litigation, you want to make sure that conversation is going to be privileged. And so, wait, are they talking now as a board member or as an attorney? Is there something in place that's going to be able to show that you are the client of this person, that they're just not a board member? Think about those kinds of issues, because they're the kind of things you want to be considering before there's a problem and not after.
Awesome. All right. Time for polling question number 2. Everybody get ready. The question is, to qualify as an excess benefit transaction, the value of the economic benefit must A, equal the value of consideration, B, exceed the value of consideration, C, surpass the value of consideration, or D, unsure. Right, it looks like everybody knows this one right off the bat. We're at about 70% voted, so we'll give everyone about 5 more seconds to click away. If you're looking at a work paper right now or looking at Excel, make sure you come back to the webinar and click that link real quick and vote. Okay, we're at about 80% voted. All right, and the correct answer is B, exceed the value of consideration. All right, confidentiality and liabilities.
Thank you. So when it comes to confidentiality, one of the things I want to make sure is clear, and it's really mostly an emphasis of things I've said already, is when you have board deliberations, those should be confidential, and of course you should be educating your board members about what that means ahead of time. It's confidential, but it's not privileged. So unless it's attorney-client privilege, there may be other privileges that I'm not aware of, attorney work product privilege, those discussions could be discovered one day. And you deal with many situations where there's litigation, there's discovery, and when I'm involved ahead of time, I really work hard to try to keep board members from becoming witnesses, from being deposed. But keep in mind that the things you say could be discovered. Even more than that, emails. The E in email, a lot of people think of as being electronic, but I think of it as evidence. And you want to make sure you're not sending emails around, encouraging your board members to do that when that could be discovered. So it's really important to make clear to all your board members that one of their obligations is to come to board meetings to keep those conversations confidential. It doesn't always happen. I think they're not always trained, and frankly, I think it's human nature sometimes for people to want to go home and tell their spouse or somebody else about all the juicy things they learned at the board meeting, and frankly, they shouldn't do that. And it goes back to something I mentioned at the very beginning of the webinar, which is that frankly not everybody is meant to be a board member just because they give lots of money, which is great, just because they have expertise, which is wonderful. If you have somebody who you really don't think is going to be a well-behaving board member, I think you should avoid that problem by not putting them on the board. There's really interesting studies I've read about bees, where bees go out, they look for new places for hives, and they have very strong feelings about where the hive should be built. They fly in circles to communicate like how great they think of a spot it is. Once the decision is made, though, everybody works together. And that's the way that your board needs to function. Okay, in terms of personal liability, which is the next slide. Right there, thank you. Generally, I want you to know that trustees are protected from personal liability. They can still be named in suits. They often are, to try to put pressure on them. You can try to get them out. There's corporations code listed there. For religious corporations, it's 9241. But they're not always going to be free from liability if they go sort of beyond their role as a trustee, or they engage in some other misconduct. So that last bullet point there talks about tortious conduct. That would be something like defamation. If you have a board member who goes out in the community and starts talking about this person is a thief and a criminal and making false statements about them, they could be personally liable for that. By the way, generally speaking, when you think about the law and you think about protecting your board members from personal liability, it shouldn't come as a surprise that there are protections for board members, because the law wants to encourage people to serve as volunteers on nonprofit boards. So there definitely are protections for them.
Yeah, Michael. So this just highlights the fact that, you know, everybody wants to be protected for the volunteer time they're giving back, but just there's a couple big do nots, and they just do not do the self-dealing and do not, you know, don't do the tortuous conduct. So that's what I'm hearing.
Absolutely. Yeah, definitely. This slide, I'm not going to get into the details of it. It goes over sort of what's required for volunteer directors to avoid liability. I do want to point out there's that corporations code at the bottom. When I was working on these bylaws this morning, one of the things I put in there was that the corporation shall maintain at least the minimum insurance required under this statute, and that's to make sure that people will, you know, be protected. There's an interesting case I want to mention just very quickly, where a school went bankrupt and was sued by the people that issued the bonds, saying, hey, we relied on statements by board members in issuing these bonds, and we want to be able to recover from them personally. And they were not able to do that. These statutes protected the board members from liability, but one of the important things was the court specifically noted that they were simply acting in their role as board members, that all the statements they made that the bond company relied upon were made in their role as board members. And that's something else. I often find well-meaning board members who will say, you know what, let me go talk to this person. Let me go out. Let me see what I can do. And when they step out of their role as a board member, even though they may think they're acting on behalf of the organization, and I'm sure they think they're acting in its best interest, that can potentially create liability for them. Okay, indemnification of directors. Indemnification is different. Indemnification is where the organization would be responsible for any liability that was found, and there are statutes that govern this. I had a really interesting conversation about a month or so ago with a